Apologize because it is 0805. We were going to start at 0800. Start with it's great to have Senator Kay Kirkpatrick with me, who is now an official member of the leadership of the Georgia Senate Caucus. When I first came into the Senate, Kay was my seatmate, and or Senator Kirkpatrick was my seatmate, and you can look at us and tell we don't favor very much, but after a few days, we realized that we have a lot in common in our personal lives and everything else. We really hit it off. She's been an incredible friend, colleague, and counselor at times. And she and I, when this committee came together, if there's my passion about addiction and all this came from my 30 years of dealing with it and even dealing with it within my family. I had a cousin who was extremely close to me. I have some artwork in my office that reflects memories of him, and he literally drank himself to death. And I left a fundraiser one night and got a call from my other cousin asking me to meet him at Glenn's house. And for some reason, my response was, "Is he dead?" And he said, "Yes." And so I went there, and Glenn and I grew up together, and he was so much more intelligent than I will ever be. He was just a great guy, very compassionate guy, and an extremely good cousin. Growing up as an only boy in my immediate family, he was much, much, much more like a brother than a cousin, along with my other cousin Douglas. And so it had an impact on me, whether I cared to admit it or not, and it made me angry that we look at individuals who become addicted as lesser than, and they're not. I think we are just absolutely blessed that we have not fallen into that same disease. And so finding somebody, a colleague that has as much concern and compassion and drive to find some kind of solution to help these folks inside this building that are not doing it for their own self-service is extremely difficult. But Senator Kay Kirkpatrick is absolutely the person in the Senate that has that passion and has that compassion, and I'm excited that she was able to help me with this committee, and I'm always going to be indebted to her for everything she's done for me while I've been up here. This will be the last meeting we're going to have. We have a couple of people that have reached out and said they're going to be coming in a little late. They're mostly state employees, which I know 8 o'clock is really, really early for taxpayer funded employees, with the exception of the men and women you see sitting up here, a staff that shows up. If I were to schedule this meeting for 5 a.m., they would have all been here early and look as fresh and professional as they do right now. And they make us look a whole lot better than we are. One person I want to give a serious shout out to is Jackson with Senate Press. Jackson handles all of my stuff. They divide us up like cattle to the Senate Press, and I always feel sorry for the poor individual that ends up with me because I'm not the easiest guy to deal with. Because of my dark sense of humor and my absolute disgust with government and everything associated with government. So Jackson makes me look somewhat human, and I really do appreciate that a lot, Jackson. And thank you for always having my back and putting up with me. And also Ledge Council for I learned a whole lot about the law in 30 years. I speak more Latin than any deputy sheriff should ever know from standing in courtrooms and everything from capital murder cases to domestic violence cases. And I have never, it has never fallen short on me how chaotic this world will be if we did not have professional attorneys, lawyers, whatever you want to call them, except the bad words, that always keep us within the guardrails. And legislative council does a great job in doing that, and I really appreciate them being present and helping us also. So DBHDD, I know they're running a few minutes late this morning, and it happens to be y'all's attorney that's running late, right? That actually serves on this committee, and she has been invaluable, and we do appreciate the commissioner given her to us during this time for this task. We do have our a draft report completed today. We will make recommendations, and I'll say this to the committee members that are listening in, and to Dr. Kirkpatrick, is that right now, I think a lot of the recommendations we will make will be administrative type recommendations within DBHDD and DHS, as far as changing of policies and some consolidation of tasks and things of that nature. We're trying to stay away from legislation as much as possible, because the worst thing you can do to something that's working fairly well is to hand it to the 180 or the 56 in this building and ask them to fix it, because when it's all said and done, we'll be fighting over semicolons and shalls and mays and everything else, and we can really cause a train wreck some days while attempting to do something to better the lives of Georgians. So I think the vast majority of the recommendations that we're going to really push for are going to be adjustments within the systems. So I appreciate everybody being here. And with that introduction, if y'all will bear with me, I will ask you to bow your heads in silence, and we will say a brief prayer. Dear Heavenly Father, we ask today, Lord God, that you come into this room, Lord God, and you give us the wisdom, understanding, and compassion, Lord God, as we walk through this sensitive subject. I ask that in the end, Lord God, that it would be evident that our minds and our hearts are open to a unique population of your children, Lord God, that need our help in this time. And with that, I ask all your blessings on everyone present today in the name of my Lord and Savior and your Son, Jesus Christ. Amen. All right. Over the last couple of meetings, we've had a gentleman come in by the name of Ian Neubauer. And Ian, if you would come up, and we want to do a brief recap over some of the issues that we've had. And we did receive in your packet is a reasonable zoning accommodation request application, I think. Did you provide this?
Did not.
Okay.
But that's okay. I can talk. I'm sure I can speak to it.
Yeah, it came out of College Park. Is that where we were having the
That's
problem
where
last time?
That is.
Yeah.
So I'm guessing that my client
Yeah.
provided that.
Yeah. Have you seen a copy of it?
I have.
Okay.
Yes, sir.
And so what I really want to touch on, we have ACCG here today and GMA, and what I want to touch on is the dilemma that we're running into, just an overview on getting these residences zoned properly. And I think last time, and if you want to touch on it, I don't have any problem with that. We touched on what we feel are some violations pertaining to the legislation that was signed by President Reagan, or the policy changes that were put in place by President Reagan back in the early 90s, maybe
88.
late 80s.
88. Yes,
88. Okay. So if you could do that and get us up to speed on that, I greatly appreciate it. And you're at mic 1.
Awesome. So
Thank you.
again, my name's Ian Neubauer. I am the owner operator of Second Chance Recovery Residences here in Atlanta. So we're a sober living program in Sandy Springs, Roswell, and soon to be Grant Park. I'm also a licensed attorney, and so I wish Kai was here. He's my client. He's the one that's going through the dispute with College Park right now, what Senator Robertson just alluded to. So high level summary from the operator's perspective, the biggest hurdle facing recovery residences right now is zoning, stigma, NIMBYism, and just outright and from my perspective, discrimination against who we are, what we do, and what we're not. Right. And so in the instance of College Park, I'll just give a summary of the facts there. My client is planning to open a sober living home.
Ian, just for the sake of everybody, give us a definition, your definition of a sober living home, if you would.
It is a residence that provides community peer support and promotes and requires a drug and alcohol-free lifestyle.
So to be clear, we're not talking about a healthcare facility, right?
Not in the slightest. No clinical services whatsoever. It is peer support through and through.
And in most cases, if I walked into these residences, would I feel that I was in somebody's home?
It is a home. You would not be able to drive down the street. There's no signage. There's no, I mean, we have LLCs, we have business program names and the like, but I mean, there's no distinguishing factor. If you were to drive down a street of single family residential dwellings and someone were to say, pick out the sober living home, you wouldn't be able to do
So when I walk inside, there's not a waiting area, receptionist desk, some
Absolutely.
plexiglass
No.
to hide the
No.
receptionist behind or anything like that.
Absolutely. It feels like it's a family.
Yeah.
The goal of a recovery residence, from my perspective, and I think from anybody who is operating them properly, is to create and emulate a family, right? Of like-minded and similarly experienced individuals, because especially for people who are coming out of residential treatment, a clinical setting like you're describing, it can be a lot. And being immersed back into your old habits, your old routine, your old lifestyle, I mean, that can be too much for people, and oftentimes it can cause them to revert back into old habits and
Okay.
past problems. So the goal of
That's- yeah.
recovery residence is create a family that props one another up, supports one another, and during those critical months or years, I mean, there is no time limit. Allows people to get back on their feet and build their support system with.
It's almost a fraternal atmosphere, you would think, where people with like needs
Precisely.
and I'm not talking about like a college
Right, that's
fraternity.
not
Yeah,
one of
no.
the, yeah.
I'm talking about just
Absolutely.
people with like needs and peer support, things like that. Yeah,
100%.
Okay. Thank you. I appreciate that. And now we're
So-
back to the zoning.
College Park, my client, he leased the house, and the family that, this is a critical factor. The family that lived in the house immediately prior to my client was a family of 9, okay, related individuals, but 9 people in total. And the house is a big home. It's spacious. My client advertised that he was going to be opening a sober living residence. I think the owner of the home actually, and in a good faith attempt to meet the neighbors where they are, told them, hey, there's going to be a sober living residence at this house. Just wanted to tell you guys, it's not going to cause any problems. Parking won't be an issue. Everything's been resolved, but here's what we're planning to do. That caused an uproar.
Now, Ian, does that owner, so they just lease the house to your client?
To
correct?
my client, yes,
So
sir.
your client did not purchase the property?
He has not.
Okay.
He has not.
Okay.
That started a firestorm. So within a day of,
Ian, could you move the mic closer to you?
of course.
Yeah, thanks.
Better?
Yes, thanks.
Good. Within a day of my client taking possession of the home, neighbors were calling, neighbors were faking that they were recovering addicts and alcoholics, saying, I need a bed. When my client would respond, sure, what can we do for you? They said pretty much, gotcha, we're going to run you out of town. They said that this has been,
Now, were they pretty much saying that, or were they saying?
they said that.
Okay.
Yeah, they said that. They informed my client that the matter had been escalated to the city mayor and the applicable council member. And within a day, zoning enforcement was showing up, sitting outside my client's house, 10 out of 10 days. So client takes possession, day 2.
Tell me what, they're just parked out in front of the house,
Parked
just
out
sitting
front.
there?
Yep, just assessing the situ, scoping it.
Yeah.
And we have pictures. I mean, my client has cameras.
I just love it when tax dollars are spent
Me too.
the right way.
Me too. It's a efficiency at its finest. So after the 10th day, my client, or 9th day or 8th day, it was after a prolonged period of days of code enforcement showing up at their house. My client went up to the city hall and asked for a meeting of what was going on. And effectively the city planner told them, you're in violation of, she didn't cite a specific ordinance, but you're in violation because you're going to be operating a sober living home, and we'll be in touch. And the next day, the city issued a cease and desist letter for with penalties threatened of $1,000 a day if they did not, quote unquote, come into compliance within 2 weeks. And at this point in time, not a single recovering addict or alcoholic had moved into that house. It was merely the proposed use of this residence as a recovery residence that caused this just wave of nonsense.
Did they give your client a list of a punch list on what he had to accomplish to become compliant?
Funny you should ask that. In fact, in the cease and desist letter that they issued to my client, in all bold and in all bold text at the bottom, they stated that there's nothing that you can do for you to be able to operate a recovery residence in the proposed dwelling.
Okay, so if I'm hearing you correctly, you said they sent a letter saying you have a certain amount of time to come into compliance, and then at the bottom they said there's no way you can come into compliance.
Precisely.
Okay, thank you.
And so I say all of this not to necessarily pick on College Park, but this is not unique. This is not, I mean, this is egregious and from the standpoint of how far a city is willing to take things, but pretty much any sober living operator that wants to open something is going to face something similar to this. I faced it in Roswell. I mean, there are horror stories out there. And
Well,
so,
when you say face it, I was at a meeting last night where it was brought up that somebody wants to come in and build a new subdivision.
Mhm.
And you're always going to have neighbor pushback
Mhm.
on, the whole not in my backyard thing, or, in the rural parts of the county I live in, it's a 2-acre minimum. And, everybody wants to keep everything as rural as possible, and let Columbus be Columbus, and let
Mhm.
rural Harris County be rural Harris County. But there's always some issues, but it's not always the government that's the issue. It's neighbors going before the county commission or the city council
Mhm.
stating their concerns with it. And the city council or the county commission normally has policies, procedures, and guidelines that they have adopted
Mhm.
that allows this. So are you saying that what you've seen around the state or around where you've been involved, is it neighbors primarily saying we don't want that in our neighborhood, or is it the actual city or county government?
Combination.
Okay.
I think it's a combination. I think that I think a lot of times the excitement is incited by the neighbors, right? People catch wind that a sober living home is being opened, and they phone a friend, and next thing you know, it's a big public outrage. But I don't know if it is so much bias or discrimination at the government officials level as it is ignorance of the Fair Housing Act and the Georgia Fair Housing Law and what that requires of our elected officials from the standpoint of reasonable accommodations and what constitutes discrimination and what doesn't, because it's not it until I got into this line of work, I didn't know what I didn't know. And so I think that oftentimes it's just there's an educational component to it that I think could solve a lot. Sometimes even the educational component doesn't go far enough and people dig their heels in, and you have to inform them.
In being straightforward, whose responsibility is it to educate? Is it the responsibility of the renter who wants to open a sober living resident? Is it the responsibility of ACCG and GMA to educate their members on this kind of stuff? Or is it a combination thereof? I mean, if I'm going to open a convenience store in a particular part of a city and I read all the rules and everything and I apply for everything, is it an excuse that the city could say that, well, hey, we're sorry, Mr. Robertson, we didn't realize this? Or, I mean, if I have somebody working in codes and inspections, I assume their expertise is codes and inspections and not, retrieving stray animals off the street. So, I mean, is that where we're finding the problem? And then it would be the responsibility of that municipality or that county government to educate the citizens and to say, these are what our rules are. These are what our ordinances are. And the only way they're changed is by legislative action.
So in the context of an ordinary constituent, is ignorance of the law, is that a defense for anybody else for the?
Ignorance of the law from a criminal is never a defense. Is no,
Civil.
well, right. I'm saying, yeah, I agree with you. It's never an excuse. What I'm saying is the failure of education, and I guess it's a rhetorical question.
Mhm.
The failure of education is on the governing body, correct? Because we can't assume that the local citizen who works 40 hours a week and whatever their profession is and carries on with their lives and all this are going to be aware of everything that goes on. That's the reason they elected the government body to manage their community, correct?
Mhm.
Okay, Dr. Kirkpatrick.
Yeah, we've got a lot of paperwork in our folders.
Yes, ma'am. And again, I didn't provide any of
Yeah,
that. So
that's back and forth.
And then
but
again, I did. So,
Back and forth between your organization and the city of College Park.
okay.
So I guess, I can't make heads or tails out of where this stands right now. So what's going on? If you could just address that.
And I'm gonna because it is an active matter, I'm going to answer that to the best of my ability.
when you say matter, is it in litigation?
Not yet, but
Okay. Okay.
yeah, it could.
So
very
you're using
easily.
lawyer speak, right?
I am.
Okay.
College Park has accepted our reasonable accommodation request. So when they sent the initial cease and desist, they said that there is no mechanism through which this will ever be a permitted use. I sent them a correspondence that I'm assuming is in there that says, unfortunately, federal law and state law requires that there is a mechanism called a reasonable accommodation. All of a sudden, College Park tendered a reasonable accommodation request form. So that miraculously popped up. We submitted the reasonable accommodation request form. I received correspondence from their counsel last night that it was under review and that the appropriate body to review and rule on said reasonable accommodation request is the zoning council, and that the earliest that they would even consider it is December 1.
So week after next would be,
So-
and your client's here, by the way.
Thank you.
Yes, ma'am. So that's where things stand right now. In a perfect world, so again, without diving into without nerding out on it, there are three types of discrimination. There's facial discrimination, which is a law that says a protected class can or cannot do something, singles them out on the basis of whatever the protected characteristic is. There is disparate impact, which is facially neutral law, but when applied in practice, it has an undue impact on a protected class of individuals. And then there's failure to grant a reasonable accommodation. Okay. So what I'm trying to convey to the city of College Park is that we have the reasonable accommodation request here. They are required under law to evaluate that, but their ordinance is on the book. Their definition of group home specifically singles out disabled individuals. And if when applied, their zoning code does not permit group homes, it expressly precludes them in districts that are zoned R1 and R2. Or no, I'm sorry, they are conditionally permitted in districts that are zoned R1. They are excluded, categorically excluded from R2 and R3 districts. So a group home cannot exist in those districts. That's facial discrimination. So the dispute with this city is twofold. There's reasonable accommodation, and there's also, hey, your ordinance as it's written is problematic.
Just to follow up.
Yep,
Mr.
yeah,
Chair.
you're on.
So just to be clear, I'm not a lawyer.
Yes,
And my question is the people with addiction of various sorts, are they a protected class under fair
100%.
housing?
100% under both federal and state law. And
Okay.
so people, by and large, the precedent, the guidance on these matters are at the federal level, Fair Housing Act amendments of 1988. But Georgia also has the Fair Housing Law on the books. It is a law that mirrors the Fair Housing Act. So, I mean, you can take this state or federal level. It's just kind of
Thank you.
what you want to pursue.
All right. So right now you basically have a hearing coming up
12/1.
earliest next week,
Mhm.
a week after next.
For the reasonable accommodation.
For
but
the reasonable
But the
accommodation.
fact still exists that, as it's written, the city of College Park, in my legal and professional opinion, has a very problematic ordinance on the books, and they're not unique. Again, I'm not picking on College Park.
Now, when you say they're not unique, are you talking about Georgia?
I'm talking about counties and municipalities.
Okay, and that was going to be my next question.
Mm-hmm.
Were you saying that you're seeing these not only in municipalities, which College Park is,
Mhm.
but you're also seeing it in counties also?
Mhm.
Okay. And can you tell me how you've experienced that in other municipalities and other counties?
So again, there's, I think that two ways. So the first and the most common in my experience, like,
Are we talking about Fulton?
no, not, I don't know. I think
Because where your
we're Roswell.
Roswell?
Yeah.
Okay.
And
What county
Roswell
is that?
I'm sorry,
What county?
they're Fulton.
Yeah.
But because they're Roswell proper, the only zoning ordinances I have to.
Is the municipal zoning,
Precisely,
correct?
but we don't have to look at Fulton.
Okay.
Like, so take Cobb County, for example, or the city of Marietta. They define family to include up to 3 unrelated individuals. Okay, and actually Cobb does have a definition for, I think it's group home is the term that they use, but I think they define it up to 4 unrelated individuals. So the problem that you see most often is that these cities and these counties, they define family to include a specific number of unrelated individuals. Group homes will come in. Oftentimes, the number of individuals that are permitted are prohibitively small for a group home to function therapeutically, financially, just as a whole. So a group home will come in and they'll say, hey, understand your definition of family is 3 unrelated individuals. We're requesting a reasonable accommodation for up to, say, 6 unrelated individuals. What say you? And the cities and the counties, without thinking much about it, they hear sober living home. They say, unfortunately, that's not going to work. That's how the fight starts.
Now, you said therapeutically,
Mhm.
there's a number?
So research, and we can send you
That's my next question. Yeah.
the critical mass is typically 8. Is like that's the number that people say the critical mass for the therapeutic benefits is 8. As we learned from the gentleman that I had speak with me last session, up to 12 has been it is almost uniformly agreed upon in this community that up to 12 can emulate a family successfully.
Is 12 the tipping point?
From the standpoint of does that too much?
Yeah.
I don't want to speak in certainties, but I think that more than 12, you start getting into like the institutional, less family.
And since this is your profession, you have science to back this up.
I can send you, I can send you literature.
The literature
Yeah.
that discusses the
Mhm.
value of 8,
Mhm.
if you will.
Absolutely.
Yeah. You have any other questions? No. Okay. Anything else you want to talk about? We're gonna bring our associations up and let them discuss some of the issues. I know they've reviewed some of the meetings in the past, and so you're gonna hang around though, right?
Yes, sir. I'll be here.
Okay, great. Yeah. All right. We'll
Thank you.
get thank you. We'll get ACCG to come forward. I tell you what, since we're talking about College Park, let's get GMA if they would. And I know y'all have attended, I think if not all, most of our meetings. And so, and Mike 1 and Mike 2 are hot if y'all will pull them close so that Jackson doesn't get on to me.
Well, thank you, Chairman, members of the committee. I'm Noah Ranitz with the Georgia Municipal Association. I'm joined by my colleague Rushi.
Rishi Patel with GMA.
I have some prepared remarks today, but if you'd like, I think we could start talking maybe about this question of the
It's
city of College
whatever-
Park.
Whatever you want.
Well, I think with that in mind, I'd actually like to defer away from that because I think honestly, we represent all 536 cities. There's active and potentially pending litigation in 1.
Yeah, that's the one thing I'd add. We're not the legal.
No, I
party to
understand that.
responsibility.
And I think you understood my question
Yeah.
earlier when I was talking about whose responsibility does it fall? And look,
Yeah.
I had to investigate a small police department one time, and I was working with the police chief, and he was saying, well, we don't have this, this, and this. And I asked him, was he a member of the International Chiefs of Police Association? And he said, yes. And I said, well, that's your university.
Right.
They have everything you need. The SOP model policies, everything, plug them in. And that's what I see GMA and ACCG as, is when individuals become members of your association, they tap into the wealth of resources that you have. And I believe, even though it doesn't happen, y'all's ultimate goal is continuity of operations throughout every one of your member municipalities. And I think ACCG would want that throughout their 159 members also. And so discussing from that area, I think, and talking about what we're trying to do with these sober living residences, I think is good to know. What is the role of the Georgia Municipal Association in that? And do y'all have best practices that y'all put out to these municipalities when it comes to zoning, so that we're not violating federal law or state law?
Yeah, I think I can get you where you need to be.
Okay.
As far as we're concerned there. So I'd ask you to give me a little bit of runway.
You've got all the
association.
you need. Yeah.
So I want to start by saying that, and I think this goes back to, Chairman, your preamble in the committee, is that you spent a lion's share of your life in public service and law enforcement. And I think every single day, cities all across the state of Georgia are on the front lines of the issue of unsheltered homelessness, the issues of substance abuse disorder, drug addiction. I was reading through, in anticipation of this, kind of some of the information about the opioid settlement, right?
Mhm.
And the money in which that money's coming to our cities, and they could use that to help fund programs for recovery. So I think if you look at recovery through a binary nexus, it could be just a 0 and a 1. And I think that every single day, city officials are seeing the 0, which is the individual in a community at a rock bottom position, actively abusing narcotics, actively in alcohol addiction. And they're finding ways in which they could provide support services to get that individual off the streets and into a healthy, rehabilitated.
But
facility.
let's understand now, we're talking about sober residences. We're not necessarily talking about people on the street and people being homeless. What we're talking about is Alice comes home one day and Johnny has drained all of their accounts because he's got an opioid addiction, or because he's an alcoholic.
Right.
And then she has to find somewhere to get him, he goes somewhere, he gets the therapeutic solution, and then to transition him back into everyday life, he goes to a sober living facility so he can be in a peer group for ever how long it takes. We had some groups that come in here and say it's 60 and 90 days. We had one group comes in here and they keep everybody, their average is 6 months and beyond. They've had people in their program for 2 years transitioning back in. So I don't want to get this confused. And I know you heard the term in one of the meetings, and I heard it where somebody said, we have people around the state that set up flop houses.
Yeah.
Those horrific places are more intended for what you're talking about, where somebody will go out there and there's Randy living behind some breakfast joint, homeless because he has a drug problem. Those aren't necessarily the people I would think, and I know the people that run these facilities in the room would probably correct me if I'm wrong, or I definitely know they will. These aren't the people that we normally find in sober living residences. People that need to go and be detoxed prior to getting in there. These are people that have been detoxed and are transitioning back in. Remember, I think somebody said it earlier, you drive through the neighborhood and you can't tell the house.
Yeah.
I mean, I can pick out a detox center pretty easy. Yeah.
Well, I asked for a little bit of runway. Maybe I went too far, but I think where I was going was recovery could be that binary, right? Wherever that 0 is for an individual, we understand that 1 is, in this instance, an individual exiting a recovery residence having been a rehabilitated member, right?
Right.
And I think while local governments all across the state are familiar with that 0 ideology and how do we address that, I think we can also be a part of that 1, right? Getting there. And I want to talk today about our work, I think, in recovery residences, some of the feedback I got from cities that I talked to across the state, as well as what I was able to learn from my counterparts that do my job in other states that have addressed this issue. So I want to start with something that we have done. And 2 sessions ago, Representative Dale Washburn called me and said, I have a zoning bill. And if you know our history with Representative Washburn and a housing and development bill, it was I had some anxiety. I said, well, what are we talking about here? And he told me a story about how in state zoning procedure law, there was provisions that provided extra requirements for zoning procedures and zoning variances related to recovery houses, written in name halfway homes. And we talked about why that was in law, why the state thought the need to do that, and how that existed and how that was going to interfere with potentially federal law or some other issues. We as an association evaluated that, brought it to our membership, and we said that we think in 2024, in today's day and age, that has no position in law, and we are happy to support a repeal of that. So we supported House Bill 1073, which brought the zoning procedures around recovery residences from anywhere between 6 to 9 months down to traditional rezonings, which is anywhere between 14 to 21 days. That's a level playing field for these properties. Again, I think back to those fair housing definitions and the protections. I was reviewing the definitions from the Justice Department, but it's everyone has to be on that level playing field, right? You can't be onerous in your treatment. Everyone has to be a level playing field. So putting them on that 14 to 21 day timeline that everyone else is on, that's a win. So we supported that. And I think that in itself serves as a model for how the state government and local governments can work together to improve access without preemption.
Now, the 14 to 21 day, that basically, prior to that, were we giving municipalities more time to review recovery residence zoning? Were they getting, 30 days, 60
The
days?
structure was a notice had to be put out no less than 6 months before an anticipated zoning decision would be effectuated, basically.
Okay, so we're saying 6 months?
Yeah.
It was a
So-
different process.
Right.
Yeah.
So it was a different process from normal zoning process?
Yes.
That's right.
Okay, so what Representative Washburn's bill did was remove that
Repeal that section.
to, in other words, they dropped down within but did it put them on a level playing field with other
Absolutely.
zoning, or were they a unique?
It's creating,
Combination.
from my understanding, it created the same standard as normal zoning.
Yeah,
Yeah.
because I mean, it doesn't matter if I give somebody 6 months or 6 hours, they can still discriminate against me if the rules are different, right? I mean, if they say, hey, look, Senator Robertson, we're going to put you and Ms. Cope on level playing field, but in the rules, your hair's not long enough. So look, it doesn't matter if you give me 6 months or whatever, my hair's not going to grow like that. So I'm done, and we're talking about something really unique, not as where, people come into neighborhoods. I can understand, somebody's coming in a neighborhood and want to put a dog kennel in the middle of a neighborhood and all this other kind of stuff. And the zoning required around that is very unique into itself. But what we're talking about here are human beings
Yep.
moving into a neighborhood, and where zoning is R1 and R2 for the most part. And so I think that's where our thing is. While I appreciate, and I think it made a lot of sense what
Yep.
Chairman Washburn did to get the time limits right, it still didn't alleviate the opportunity for discrimination, correct?
I think,
It just didn't address that.
yeah, I
Yes,
didn't
yeah.
address that part.
Yeah.
So, I mean, I think that's probably something that could occur in almost any situation.
No, you're exactly right.
So-
Yeah. So while I understand that and I appreciate that, and again, anytime somebody comes to me about a zoning thing or any of that kind of stuff, I bring up your name or Todd's name and said, go talk to them and come back and see me.
We appreciate that.
Well, I said, you can either talk to them now or I can argue with them later. But if you talk to them and come back and they say it's okay, I know I don't have to, I know you're right. Because you guys are the experts when it comes to that. So while that did do that, and I appreciate that.
Yep.
And I know everybody appreciates when zoning gets less and less, and we are looking at more legislation to clear that process up. But I'm still concerned that it doesn't alleviate the opportunity. And I understand the failure to follow federal law and the failure to follow state law. That is not a GMA and an ACCG problem. That's a local problem that somebody's not doing it, whether it's the county attorney, the city attorney, or whatever. But the the writing of the ordinances that, or the practices that lead to this is a concern.
Well, one thing I would touch on with that is the failure to follow federal law. You know, the example that was brought forth before us with College Park, again, you know, we don't represent College Park. I don't know all the facts of what's
Right.
going on there. But what I heard from the testimony was first that, you know, they got a cease and desist letter that said you can't do anything about it. But then it sounded like they are being able to do something about it. I was actually, while I was sitting there, I was able to pull up the letter with the cease and desist. And the last thing in that letter says, you have a right to appeal. Here's the process for appealing. So it wasn't an end all even in that letter. And it sounds like they're having ongoing discussions at this point, even until last night.
And I
Yeah.
agree with you 100% on that. My thing is reading through everything I've read, we shouldn't even be at that point.
Well,
And what I'm trying to say is I do you wrong. And I say, hey, look, I'm going to do this to you.
sure.
You know, and look, I took an oath to take away people's freedom and I did it. And I used to tell everybody that worked for me, you know, you can't unarrest somebody. Once you put handcuffs on somebody and they are arrested, it's the court system's determination then whether you make good or bad. So I come up to you and I mistreat you. I go outside of my qualified immunity and you're beat up, busted up. And I go, hey, you can file a complaint. Well, that doesn't take one stitch out of your jaw or one drop of blood back in your body. So that's my concern. And so, and look, I worked for a very large government for a lot of years. I worked for the consolidated government of Columbus, Muskogee, very well-run city, very professional, very proud of it, that are members of ACCG and GMA, thanks to consolidation. But we would have had a stroke if somebody sent a letter out saying, you know, these, I would want to talk to the admin that sent out a cease and desist to begin with. I mean, and then there was the problem. And I don't want to talk about College Park specifically because I don't want to bring in the legal. I
Sure.
don't want to put any of y'all in a bad spot.
Well, talking more in the general terms of, you know, the situation you're talking about. Well, obviously a business doesn't want to be put in that situation where they could have a litigation, they have additional costs they didn't plan on. But one of the things that I would point out is the state of Georgia, and this is from the Attorney General's Consumer Protection Division site itself on recovery residences. And it says, these residences are not licensed in Georgia, so while some are legitimate, others may provide substandard living conditions with the goal of lining their owners' pockets rather than supporting their residents' recovery. And it goes on. So the challenge that you see at the local level is they get an application for this and they don't know if it's a legitimate one that's been, you know, approved by various organizations that have some standing, or if it's just somebody coming in trying to make money. And I think the challenge that they're having from a local level is they're trying to follow the zoning process and follow the zoning laws that they have at their local level and the zoning procedures set by state law. And in situations like this, you're going to have active litigation potentially, or you're going to have active discussions. And right now it sounds like that one situation, we have active discussions. Hopefully it doesn't get to active litigation, but
Right.
you know,
And
I
what
think-
you just read is exactly the why this committee
right.
was put together because of exactly what you just read. There is no licensing
Right.
and there should be. We want to protect, even more so, I want to protect the family of the individual who is getting back
Absolutely.
into society, because they're the ones usually footing the bill for it. And they're usually the ones being taken advantage of by the bad actors, which is what brought this to my attention when a constituent was trying to get his daughter into somewhere to deal with her alcoholism. And basically he was being asked to commit insurance fraud in order to put the square peg in the round hole. And then he couldn't find a sober residence place he could get her into to transition back. So she just kept flipping right back and going off. But, and a lot of times we just need government to get out of the way. But in this case, that what the AG wrote, and, you know, I love opinions. Opinions are not law.
Right.
I love them, and attorneys write great opinions. But that is the problem that myself and Senator Kirkpatrick and all them are trying to solve, how we have a very clarified system to where they can be licensed.
Mhm.
But it has to be something that is, and I hate this word, but it has to be something that is fair and it has to be something that is compliant with all state and federal laws.
Yeah.
Dr. Kirkpatrick.
So I know a little bit about this because I was the author of Senate Bill 5, which defined recovery residence. And it also, after that bill passed and was signed, I worked with the Attorney General's office to put language on their consumer protection site. And when you say it goes on, my understanding is that there's a list of GAR certified
That's right.
residences on the website.
That's right.
So it's not really left entirely to chance whether a facility is certified or approved by GAR.
Sure. No, I agree with that. I think you might have new folks coming in too that might not have gone through that whole process of getting certified.
And that's the problem. GAR is a voluntary
Right.
certification. And so if I open up one tomorrow, it is not going to be on that website.
Right.
Even if I went out and got GAR certified, it wouldn't necessarily be on there. And then we have another website, another list over on Thor with, I think, DBHDD that has the Thor list. And then we have a lot of residences. We had one come here that's very successful, and they're not on either list because they weren't aware of any of the lists. And I promise you this, as we talk about dysfunction within county government
Mhm.
and local municipal government, we are absolutely not being hypocritical because we understand the vast majority of the bureaucracy rests within the state government. And it's us not doing our job that many times pushes the pressure down on the locals that they end up taking a beating because of our inaction. And so, I had somebody told me, I heard somebody say last night, they called a state agency. They're making a point of calling a state agency for the last 21 days and they've yet to speak to a human being. And I mean, that's the epitome of bureaucracy and dysfunction. So I understand it's at all levels. And this is something that needs to be cleared up so that when we do have a clear licensing protocol, that the locals are, that weight's taken off of their shoulders. They understand what is and what is not a legitimate.
Absolutely.
And we need to make sure that there's continuity when it comes to zoning too. That when somebody does get that licensing, they are able to go into whatever community and open it up as long as they comply, as long as there's not 47 cars parked on the street and all the grass in the front yard is nothing but dirt.
And I think that's the partnership
Right.
that there exists an opportunity for here is, as a state, you codify a framework of licensure that tells this is a certified recovery residence, and this is going to provide value to that individual. If the state can work to provide that, we as local governments can look to that. I think we even as GMA, it came up during the last session, the discussion of model ordinances.
Mhm.
We don't have a model ordinance on this topic presently, but if the state gives something,
Parameters. Yeah.
parameters are the full faith and credit of backed by the state government, and they said this is a recovery residence, we can then proffer model ordinances that say cities all across the state of Georgia, this is something you should look at adopting. This will get you into compliance with not just aspects of federal law, but also aspects of state law, and provide these as a resource in your community, which are like.
Does it, and I don't want to, I don't want to ask y'all to speak for your board or anything else, but would it not make even more sense if the state didn't even get involved in the licensing? We very clearly defined what these are and allow the licensing aspect to be the responsibility or the discretion of the municipality and the local government. Just to take that extra layer of bureaucracy out of the mix, if we just define it
What I've seen,
very narrowly.
Well, I do think defining it would probably be a good first step.
Yeah.
And we could see what happens from that to see if that is helpful at the local level. I think that would actually help us on even
Because a
developing.
lot of times what we do is, the Secretary of State's office will charge somebody to get this.
Yeah.
And then the local government, of course, has an investment in time and HR costs to have somebody go out and license it. And so what we're doing is we're telling somebody, yeah, you can open up one of these after you walk around the room and pay everybody for doing their job. And then, eventually get you in there, where our thing is, I think, to get these done as efficiently and clean as possible and just let it be handled at the local level with us just giving a very clear definition of what one of these are.
I think that's fair. And I think what you're describing is largely what I was able to speak to a counterpart in Kentucky. That was largely what they did in Kentucky. They had some definitions promulgated at the state level. I think they came in one year, they came back another year and played with that a bit, got it where they wanted it, and then kind of just deployed that for local governments all throughout the state of Kentucky to say, here's the bench, here's the benchmark, you meet it. right?
Okay.
And we don't want to hear about issues at the local level of onerous regulations that are outside the confines of what exists at state law or federal law.
That's right.
Here's the goalposts. You hit them. So
Anything else y'all would like to discuss about anything other than College Park?
Not College Park.
I just want to say this is something I've been following all off season, one of the study committees. I appreciate the work. I've never seen some of these study committees go as long as they have. So kudos to you all and kudos to your staff. I mean, these are long discussions. They're necessary. And I think we stand ready to find how we can assist in this to not just best represent the interests of the state, but also our cities.
I really appreciate that. And, that reputation, I promise you, it's not going out there and trying to get that with 5 a.m. or 6 a.m. study committee hearings on speed cameras. Again,
I've had a couple 5 a.m.
good
meetings in
friend-
your office.
my good friend Chairman Washburn had and all this, but I do think, and look, you all represent governments. We hold lives in our hands each and every day. And to rush through, to set a hard stop on how we impact lives, I think is, I just think it's idiotic to think that we make decisions up here that are not going to help and hurt people if we do not do the job the way we do it. And, everybody uses the thing herding cats. I can't imagine. How many members do y'all have?
536.
That's insanity to have 536 municipalities with the tens of thousands of egos that y'all have to deal with. I mean, I only deal with 50, so 60 egos in the Senate because of schizophrenia. We have multiple on some, but I can't imagine what y'all do. And nobody's ever wrong, which is why anytime we got an opinion from an attorney and one of our law enforcement professionals in the room would said, well, what do you think about? And I said, well, all I think about now is what the attorney said. So that's what we're going to do. Whether we love it or not, it's the right thing to do. And so I know that y'all have to pull your hair out sometime trying to manage that 500 plus municipalities. And while I understand that, this isn't always the paramount discussion because, to your point, there are a lot of problems in municipalities, whether it's homelessness, whether it's gangs, whether it's paving roads, and sanitation issues, trash pickup and all this other kind of stuff. People drive by county jails, prisons, and recovery homes, residences, and other places every day and do not slow down. They don't know what's in there. They don't care to know what's in there because it's not important to their lives. But as far as us being public servants, it is our responsibility to make sure that even those marginalized citizens in our communities who are pushed back in the corner, that they get taken care of as well as those who are flourishing. And so I do appreciate the work y'all do. Now, that does not mean I'm going to agree with everything y'all do this coming session. I'm sure I won't. What is it? Richard Pryor's dog told him, hey, Richard, I hate to see it happening like this, but understand, next time I see you, I'm gonna bite you. But no, I really do appreciate you guys a lot. Thank y'all for coming in today, and thank you for tracking everything. That means a lot.
Absolutely.
Thank you, Mr. Chairman.
All right, what everybody bought tickets to see, Todd and ACCG.
Thank you, Mr. Chairman, Senator. Todd Edwards, I'm the Director of Governmental Affairs at the Association of County Commissioners of Georgia. And we appreciate being invited here to speak before you. I know there's been a lot of discussion throughout the course of these hearings, and they've been good. I've learned a lot. Zoning, federal law, state law, and housing. I'm by no means an expert in those areas, so we have with us today, I'm delighted to have join me our General Counsel, Mr. Larry Ramsey. He's got several decades of experience in both private practice and county government, largely focused on zoning law. So I'm going to turn it over to Larry, have him introduce himself, and present some from the county's and ACCG's perspective.
Well, thank you, Todd, and Mr. Chairman and Senator. Thank you for the opportunity to be here. As Todd said, I'm fortunate enough to be General Counsel for ACCG, and I've been doing that. Been with ACCG for 8 years. But as he said, Spent my career prior to that working with county governments as a lawyer, most of that time in Fulton County, the county attorney's office, where I primarily focused on zoning law until it became a municipalized county and zoning no longer was an issue for the county. And then in private practice, working in zoning. So it's, as the years go by, I have not been in zoning directly, but I still think of myself as a zoning lawyer. And so I'm happy to be here to try to offer any information that I can.
Has there ever been a weekly television series about zoning attorneys? I know there's
if,
criminal,
you know,
civil, and
If there was, I think it didn't get past the pilot stage because nobody would want to watch that.
I'd watch
you,
it.
you would.
You know, my wife is an attorney and folks ask if our kids want to be attorneys and they all said they couldn't imagine anything more boring than sitting around when they listen to us talk at the dinner table every night. So no, I don't think that would be a successful show,
It's
Mr. Chairman.
fascinating.
I think, you've heard a lot about the Fair Housing Act, and I'm not going to go over that. I think what you've heard is mostly consistent with my understanding of the law. Clearly, local governments cannot be intentionally discriminating against housing for persons with disabilities. The Fair Housing Act says handicap, but it's defined as the same as disability. And I think we all agree, people in recovery from drug or alcohol addiction, it constitutes a disability. And so that's, we're all in agreement on that. The Fair Housing Act also says that these types of housing for disabled people, recovery residents, and we heard a lot of different terminology regarding these types of housing arrangements. They cannot be treated less favorably than other congregate housing for unrelated persons. So if you have special rules for a sober living house or recovery residents that are more restrictive than, say, a bed and breakfast or some other type of congregate living arrangement, that's a problem. That's a Fair Housing Act problem. And then in addition, as Mr. Neubauer said, and I think Mr. Lauber talked about as well, local governments have to have a process to entertain reasonable accommodation or accommodations requests and then determine whether they're reasonable. The Department of Justice has said that's a case-by-case determination. There is no one-size-fits-all as to whether any given accommodation is reasonable, but the local government has to receive that type of request and consider it in a case-by-case situation and determine whether that facility in that location can reasonably located there on whatever parameters are being offered. One thing I do want to say on the direct zoning perspective, so Mr. Lauber spoke, he's clearly a national expert on fair housing law, but his premise, and I appreciate what you said, Mr. Chairman, about the way this committee is leaning toward his recommendations. But Mr. Lauber and others had recommended a statewide preemption on local government's ability to set occupancy limits, for example. I think Mr. Lauber recommended 12, that the state should say, if you have up to 12 people, then they can be located in any single family zoning district. Mr. Neubauer talked about 8, 8 to 12 being the range. But Mr. Lauber's premise was that the zoning power resides with the state of Georgia, and it's been delegated to local governments, and the state of Georgia through the General Assembly could take that back. That's not an accurate statement of Georgia law. That is accurate in most states, that like other laws, other delegations, the state legislature says here, cities here, counties, you can do this. Zoning in Georgia is a constitutional matter. So the Georgia Constitution says that the substantive power of zoning resides with counties and cities. The General Assembly has the power to adopt procedures around the adoption or the use of that zoning power by local governments. And the General Assembly certainly has done that primarily through what is called the zoning procedures law. A point on that and some of the timing, it may not be relevant. What the zoning procedures law says for any zoning application that comes to a local government, you have to have notice, signs on the property, and a public hearing that both sides, both the proponents and opponents, get to speak for at least 10 minutes. And notice of that public hearing has to be published between 15 and 45 days before the zoning hearing. So that's the across the board rule. And interestingly, you heard Noah talk about the provision that went away with House Bill 1073. It's interesting on timing. So as you've heard, the Fair Housing Act amendments in 1988 expanded that protection to housing for disabled persons, for familial status, some other categories. In 1998 is when that provision in the General Assembly, so present company accepted, put into the zoning procedures law this additional procedural burden for drug recovery residences. And it's actually on top of the normal zoning rules. And so what that provision said was, as our GMA colleague said, that there would be an additional public hearing held at least 6 months and as much as 9 months before you would even start the normal zoning process. So if the and there was heightened notice requirements in the newspaper, bigger print. You had to make sure everybody knew that this type of housing was being proposed. I certainly don't know the incentive behind that provision, but it was on the books and for more than 25 years until Representative Washburn's bill. And we also supported repealing that so that this type of housing is on a level playing field from a state law perspective when these applications come in. And as I was listening to some of that discussion earlier, and you talked about the education piece. And I think what we've seen is, and this is the case both at local ordinance, but state law, you don't know if there's a problem usually until somebody raises it, right? And so from my perspective as a zoning lawyer, I always thought that that provision of state law was violating federal law by making it harder for this type of housing to locate. It was never challenged to my knowledge until it was repealed. And so it's one of those things we didn't know it was a problem because nobody brought it to your attention until Representative Washburn's bill. And so now we're on a level playing field. And I think that happens at the local level as well. We may have members that have ordinances that are not sufficiently up to date, that are not properly creating a structure for dealing with these type of housing proposals. Some of them do, some of them don't. Zoning, as you know, is a very much jurisdiction by jurisdiction approach. Different communities have different needs. It's a very public process. You may have been through this. It starts with the comprehensive planning process, a very protracted, public centered process, and then the adoption of a zoning ordinance. You got to go through public hearings, notice to the public, opportunity to speak. And so it's a very drawn off and very individualized process. And so there may be ordinances that are problematic. NIMBYism is real. And as you said, Mr. Chairman, that happens everything. It doesn't matter. It's not limited to this type of housing when people don't want something to come in. It is, in my zoning days, people used to argue, well, this is just a political decision and that you're making on this zoning. Well, the process is political. I mean, political doesn't mean it's wrong or bad. It's a public input process. And so that's simply part of it, but our members need to be following the law. I think what you've heard, and I certainly don't know anything about the College Park situation. The only county I've heard mentioned was Stevens County in an earlier one, and there was a statement that Stevens County had adopted a moratorium against this type of use. Todd followed up with Stevens County, and it was told that it's not true. They had a commissioner, because there had been many of these types of applications, maybe we should look at a moratorium on this. That did not go anywhere. As I understand it, consulted with the county attorney.
That's correct.
And after that discussion, realized that would not be appropriate to say that we're not going to allow any of these. To the extent that College Park has said, well, now we've got a reasonable accommodation process it may not be the best approach, but it sounds like it's working. It is responsibility of the local attorneys to make sure their clients know what the law is. And as you said before, Mr. Chairman, we certainly are in the education field for counties as well. I think we offer 78 classes on different topics to county commissioners. Zoning is one of those.
County law as well.
County law in general. This is certainly something we could go back and make sure that we're appropriately dealing with fair housing type issues in that context. To push that information out. That's something I talk to county attorneys every day. That's a big part of my day, is trying to help county attorneys with issues that pop up for them. And I do think ACCG can have a role in helping to educate. The last thing I think I wanted to mention is I echo our GMA's colleagues' suggestion that the state help us from a definitional perspective. I do think you said, Mr. Chairman, what about licensure at the local level? I think that's beyond the capacity of particularly smaller governments to get into the licensing field for this.
Well, and I guess, I mean, a business license is where I was coming into it. If you walk into these places and, they're somewhere displayed is their occupancy permit and their business licenses is what I just sometimes I think we've all dealt with licensing through the Secretary of State's office. I mean, I can promise you the vast majority of the calls and I guarantee you Senator Kirkpatrick gets a lot from nurses and doctors and everybody else who have done everything, and they're sitting here waiting for the SOS to do their portion. And look, SOS is overwhelmed. I respect that, but I get the calls from the HVAC people and all this, and it just seems that the state, sometimes we are just so cumbersome.
They're not broken out by specifics, so the Secretary of State couldn't even pull up a list
Yeah.
when I was looking at this.
Well,
And so that was my thing. Would it not be simpler and more efficient as long as the local government had a place to go look at the qualifications and the definition of what a sober living residence is, then they could go, yes, according to state law, that is what you are. Therefore, we will permit you as that. Would be some of my thoughts on that. So
and I do think that would help because I think you've heard other testimony, but in my experience, the names matter because not everybody agrees and as to what any given term means. And even the Department of Justice and the Fair Housing Act context says, well, we're going to use the term group home, but that doesn't have a legal meaning. But here's what we generally mean: housing for disabled persons. And so I think you've heard in prior testimony, people come in saying, well, that's what we're doing, but that's not really what they're doing,
No.
right? And so giving us at the local level a little bit of structure at least, that I think that helps us so that we know when somebody's applying to be a recovery residence or to be a sober living home, we do know what that means. I do recall earlier in my zoning career, similar confusion about in the space of assisted living and personal care home. And what does that mean? And from a zoning perspective, where do we fit these in? The state through DCH over the years, over the first couple of decades of this century, came up with classifications and there's true licensing schemes there as well. But now we know, if someone's a personal care home, we know what that means. If it's a intermediate care home, we know what that means at the local level, and you can help fit that into your zoning scheme. Again, I think that would be helpful for our counties and cities in this area to have a little more, if we're all on the same page as to what any given terminology means, that's simply going to make it easier. I think it also makes it easier for our elected officials to tell the citizens what this is and what it isn't, right? This is what state law says this particular use is and what they can and can't do. So again, I really appreciate the opportunity to speak. I'm happy to try to answer any other questions you have, and always appreciate, Mr. Chairman, your openness to hearing our comments. I know ACCG and doesn't always agree with your positions, but I appreciate your open. You've always been very open with us, and I think that's all we can ask for from our perspective is to be heard. And again, I thank you both for the opportunity to speak today.
Well, I think it's on rare occasion that Todd and I are contrary.
Yeah.
I do appreciate all y'all's help on the direct appeal stuff this past session, and I think again, we see all of you as subject matter experts that help us do our job better. Dr. Kirkpatrick, of course, is a surgeon, and look, I'm just a cop, is all I am. And so we could not do it without having that. And I think what we see in College Park is a self-correction. And I think that a lot of times the things that make these things look worse than they are when the egos get involved. And a lot of times the best exit is just an apology and a correction. And people think that because of the way the media is going to make it look and everything, it makes them look bad. And we have to get beyond that, I think, as government. Every government is drinking through a fire hose each and every day with complaints about trash cans not being picked up or potholes or crime or whatever's going on. And when people don't like the way they do things, a lot of times governments, county governments and municipalities get very protective and defensive. And we don't always need to be that way. And senators do it too, and representatives do it too. And a lot of times, and ignorance is not a bad thing. It is, we are all ignorant about something. And so many things. And so I think we just have to get beyond that and do what's right for the communities that we are responsible for. Todd?
I don't have much comments, but you do raise a good point. A lot of times folks don't like what their local governments are doing. We represent 159 counties, and that escalates often to this level at the General Assembly. We get involved and, try to, it's either, we heard the county mention, we'll call them directly. Oftentimes, again, I'll have their attorneys talk to our attorneys to make sure that they get an accurate understanding of the law. And last thing we want to do is, have the misunderstanding raised to this level without, and there's going to be a reaction. And so we do get involved. Larry mentioned we have training, we have discussions. Sometimes we read in the newspaper, but it's in our best interest to make sure that they are following the law once it's passed at the local level, county level, be it federal or state.
Dr. Kirkpatrick, you're on.
Yeah, I may be jumping ahead of you a little bit.
Your legs aren't that long.
Yeah,
but
but
yeah.
when we get to our recommendations from the committee, one of them is about studying zoning issues impacting recovery residences. And we may, based on what the testimony has been, want to add something like including development of a more specific definition of recovery residences.
Yeah, and I think that, and I agree 100% that zoning is not to the degree that individuals were asking the state to become involved. It is, first of all, I think, like you said, I think there'd be some constitutional issues with that, but the other side is local control does matter to us. And in some areas where we get involved, where, and look, full disclosure, I carried the de-annexation bill for Buckhead City. And that was basically a voters' rights bill, a citizen's right to self-determine, as some maybe wanted to portray it as the state trying to get itself involved in local government beyond what it should. It was not. But I say all that just to say I do have a tremendous amount of respect for local control. I think the local governments, they're put there for a reason. The county commissioners are elected to carry out the wishes of their constituents, just as city councilors are. So I don't think we the state need to stick our nose into zoning issues on a granular level. It's just when and again, the problem is being solved in this one municipality. But when one does come out with something like that, I think rightly so, those that are being wronged in many cases have to reach up to the state just to shine the bright light on the local government and say, hey, we can't do things this way here. And so I think, and I'm sure both organizations may have a different view of it. I don't think the state really wants to get into local control that often, but we do hear it during sessions that there are times when we have a legislator who he or she are attempting to help a constituent and kind of cross that boundary and to the point of meddling in some situations where I don't think we need to be. So I appreciate you bringing that up. As far as the responsibility of the state legislature is, like you said, to look at certain processes, but not to get in there and try to do blanket zoning, because the four counties I represent are all four unique communities. And what is good in Meriwether would not necessarily be good in Troop, nor in Harris, and what's good in Muskogee would not necessarily be good in Troop. So I respect that a lot, and I appreciate that y'all bring that kind of information out to the public. Because most of the failures that we experience up here when people come and complain about it is it's a lack of understanding, education, or innocent ignorance of somebody. And look, county governments and municipal governments that are run by people just like us. And, you know, I think I'll have to go back and look. I think I've probably made a mistake since I've been up here. I can't think of one right now, but I'm sure I have. Todd, I'm sure, has pointed it out at some point.
I was not thinking that, for the record.
But I do appreciate y'all coming and being involved in this, and thank you for clearing up the misinformation on the moratorium. Because I do appreciate, I know some counties have done moratoriums on certain things, but not anything that would have pushed back against the disabled community. So,
All right, thank you.
Thank you,
thank
Mr.
you. I
Chairman.
appreciate you. All right, Dr. Hunter Foote is going to be testifying via Zoom.
That is correct. Mr. Chairman, can you hear me okay?
Yes, Doctor, we can hear you very well.
Excellent, excellent. Thank you. Chairman Robertson and members of this study committee, I greatly appreciate the opportunity to provide testimony here today. My name is Dr. Hunter Foote, and I serve as the Executive Director of Vanderburg Sober Living. We are a national nonprofit organization which provides support to recovery residence operators as well as advocacy in support of recovery housing operations from Maine to California. And as we've heard earlier and belabored a bit, I'll echo a few points from Attorney Neubauer's testimony regarding federal law, as well as just some real world implications in terms of what this means kind of on the ground. And certainly we'll have an opportunity to have some questions after. I'm happy to answer what I can. So really what we have found in operating and supporting operators of recovery housing in many different states is it becomes easier to operate and easier to open, and just the environment is so much better when state law aligns with federal law. And as we've discussed earlier today, the federal framework is fairly well settled. Individuals in recovery are protected from the zoning standpoint under the Fair Housing Act as a functional equivalent of a family. So there really isn't the gap at the federal law level. It's a gap at the local level as it relates to these protections that are afforded groups of disabled individuals under the Fair Housing Act. So really, the state doesn't need to create any new rights. We just need the state to make the existing federal protections workable at the ground level. So what this looks like is exactly what we've discussed in the College Park scenario and probably many others that haven't seen the light of day because operators don't want to fight municipalities and they're afraid of zoning violation notices, and not everyone has the capacity to engage in this high-level conversation about federal law and state law and zoning and planning and whether building code applies and in what contexts and all of this. So I hesitate to say that this is an isolated instance of some challenges. I would venture a guess that there are countless more that just haven't gotten up to this level. So we've discussed zoning codes, we've discussed building codes, and ultimately with this disconnect between potential state legislation and the wide variety of definitions and bylaws and codes enacted at the local municipal or county level, there is lack of definition, leaving from a zoning perspective, leaving town planners, zoning boards, and neighbors just guessing at what this is, whether they should be classified as rooming houses or lodging houses or treatment, even though no treatment is offered in traditional level 2 recovery housing. And then of course, building and fire code requirements come into play as well. So right now, whether a recovery home can actually operate legally depends more on the personalities of city officials rather than what the law actually says. And that creates significant impact on human life and communities. So for residents, we see this will delay the opening or force the closure of recovery housing, which ultimately means fewer safe and sober beds. Individuals in recovery end up in substandard environments like homeless shelters, motels, or unsafe housing, or typically back to the environments that allowed them to use drugs and alcohol in the first place. And for operators in municipalities, this creates problems on both ends. Operators appeal unclear or overtly discriminatory municipal zoning requirements and codes. Municipalities have to fight or choose not to fight and choose not to enforce their rules the way they see them. There are hearings, there's litigation, there's a great deal of expense both on the private side from people that just want to operate supportive housing for individuals in recovery, but as well on the municipal side of things, expending taxpayer dollars, fighting things that may not have to be fought if there's more clarity at the state level. So every time we have to fight one of these battles, it's time and money taken away from actually doing the work that operators are called to do and the work that municipal governments, counties, and the state should be doing. So local boards are oftentimes, we're talking about these zoning appeals at the local level. They're being asked to solve a problem that they didn't create and that they're not prepared to fix, and that's under this shroud of complex federal law and court decisions from appellate courts and the intersection of that and state law, and it's very confusing. So this lack of clarity makes operators afraid to open. It makes municipalities afraid to enforce what they can legitimately enforce, and it just destabilizes everything. And as we discussed earlier, it leaves this gap for perhaps the less quality focused operators to open and just skate around and threaten litigation under the Fair Housing Act principles if people try to shut them down. So really, if we can clarify and codify at the state level laws, definitions, and provide this clarity, it will allow the right people to operate these homes successfully and grow. And it will also allow some light to be shown on those who do not operate correctly. There was a comment made earlier about requiring licensure of recovery housing. If the state were to require that recovery homes be licensed, that would potentially run afoul of the Fair Housing Act protections itself, because now the license itself is creating an impediment to these homes opening. What a lot of states have done is require any agency that receives any funding from the state. So this is the prison systems, the jail systems, probation, parole departments, and then any sort of healthcare, state healthcare funded facilities, detoxes, rehab, CSS, TSS. If everyone that receives $1 of state funding is required to only refer to certified recovery housing, it essentially requires certification without overtly requiring certification and potentially opening the state up for a challenge of that state law. So we've seen that work in Massachusetts. We've seen it work in several other states where the states say, if you're taking $1 of state money for any reason, you must only refer to certified sober living homes. And as such, it effectively requires certification for anyone that wants to receive referrals from the vast majority of referral sources.
And excuse me, Doctor.
Yes, sir.
And where do you stand on that?
I think that is perhaps the most appropriate and level and fair approach to take towards the mandate for certification. It's effective and it works well. And
what about those that don't receive any funding?
They would still be allowed to operate, and that is how it works in the states that have enacted legislation that requires this type of referral restriction.
Well, and because our ultimate goal is continuity in what sober living residences are, correct?
Correct.
Yeah, so requiring them to meet certain standards, whether they're being referred to from an agency that receives state funding or not, should not be a concern, correct?
That is more of a legal question of whether those standards that are imposed would be reasonable and necessary. I personally wouldn't be opposed to that. I've just seen similar requirements challenged.
Yeah, and because in Georgia, we have GAR, and in Florida they have FAR, and all these other certifying entities. And so if we, as long as there's continuity amongst those requirements, then I think it would be fairly reasonable to transfer those into state policy, whether that be with DBHDD or DHS, as far as certifying these types of residences, and therefore and again, I don't want to get too deep into the legal side, but I think as long as we're being consistent, that should alleviate any problems of us, of anybody. My primary focus here is getting the bad actors out of this arena and making sure that we have good, clean, safe places for people that are recovered or recovering to be able to live, work, and get their lives back on track. So I think having those kind of standards should solve that problem, right?
I would agree with that, Chairman.
Okay, thank you.
Absolutely. Yeah, and just to add a concluding remark, if it's appropriate to do so, we see on the ground what causes a lack of supportive housing is largely the lack of clarity. It's not that recovery housing needs funding, which of course it does in many senses, especially getting started up. But my ask to any body of legislature is it's clarity. It's clarity in requirements. It's clarity in expectations. It's fairness in the application of these requirements and expectations across every operator. It's openness for anyone to operate, serving folks of different demographic makeups, of different recovery pathways. But ultimately, it's the lack of clarity, and it's this froth of unknowns and whether the city is going to try to shut me down or what do I do about these notices. That stops the vast majority of people from opening in the first place or growing. And if one thing could happen, it would be that the playing field is well lit and fair to every single person on it. And after that, we could talk about funding and allocating resources and all of that. But really, the conversation should be about how do we make this as transparent as possible and as easy for new operators to understand and to take action on and to follow their dream, which many folks in this field have a dream of operating their own location. And if recovery housing is it, we should make it as easy as possible for everyone to know what is expected of them and to do the right thing in every circumstance. And with that, I'll close. And I thank you very much, Chairman, for your time in this committee and the intentionality behind thinking about this important topic. Thank you very much.
Thank you, Dr. Foote. Do you have any questions, Dr. Kirkpatrick? Okay. Thank you, Dr. Foote. Appreciate your testimony.
I appreciate you as well.
Do we have a list? Okay. Okay, good. I want to welcome Assistant Commissioner Monica Patel to the meeting this morning. I know we cut into your schedule a little bit today. I know you've been really busy, but do want to thank you. You've all the stuff we discussed today, and I'm sure you've been listening in, has really been around the zoning that you and I dove into last time, and with some of the local issues and concerns we had. And so, really appreciate you being here. You've been a big part of this. And I will say that Kennedy texted me and told me I had to be nice. So she is earning extra bonus points for some reason. I'm not sure what. Yeah, I can believe that, which is, I was surprised that somebody else hired her. But anyway, we've picked up the list. Nobody signed in to testify. Is there anybody else that would like to testify? Ian, we're going to bring you up in just a second. I see Jeff Breedlove has graced us with his presence, who is by far the one person in the state that I can say is an absolute champion for anything related to addiction in the state of Georgia. And he is he's someone that we all lean into when these conversations occur. So, Jeff, is there anything you wanted to say as we start winding down and move toward recommendations? Is there anyone here from GAR? if you could come up to the mic, I have a couple of questions I'd like to ask you, if that's okay, based on prior testimony and.
My language for that.
Senator from Fredericks. If you'll, mics, 1 and 2 are both hot. If you'll reintroduce yourself and just a few questions.
Hello, my name is Candace Whitaker, and I'm the Executive Director of the Georgia Association of Recovery Residences, also known as GAR.
Thank you, Ms. Whitaker. Appreciate you coming by. Prior, we talked about all of the requirements for somebody to receive GAR certification.
Yes.
And I want to be clear, in those requirements, were there structural requirements in there as far as fire suppression systems, things of that nature? And if so, were they any more strict than what any other home would be required to have? Any other residence?
They just require fire extinguishers that are full and tested, and then all of the smoke detectors have to be tested. And then if there is gas, that there are carbon monoxide detectors, but those are the only parameters that we have.
Is there anything in the parameters that require a plan? In other words, if somebody comes to move into the residence, Randy Robertson shows up and he's wanting to live there in sober living, that I sit Randy Robertson down and say, hey, Randy, by the way, in case of a fire,
Yes,
here's our
there's an
plans.
emergency
Yeah.
plan that
Yeah.
needs to happen. Yes. well,
okay.
Yes.
So emergency plans required and other plans associated with that, correct?
Yes. yeah.
Okay. And very personal question, how viable is GAR financially? I know at one time something was said that caused me
Absolutely,
grave
yes.
concern.
Of course.
Yeah.
Obviously, we have made changes to make us more viable. Like I said, we had moved from a 501c6 to a 501c3, and that's opening up a lot more funding for us. We have been offered fiscal sponsorship if that is something that we do need. But at this moment, with things like the Bateman Fund coming and all of these different funding opportunities, things have drastically changed for us, and we're very, very hopeful and very excited for what the future holds.
Okay. Is there a grant writer on staff with GAR?
So we have someone that we refer to. She's not officially on the board or anything as of yet, but we have a wonderful grant writer that is supporting us. Yes.
And would there be any, and GAR is the Georgia,
Yes.
but how many organizations that mirror GAR are there in the United States?
33.
There's 33. And are all those regulations consistent in those 33? And when I
So
say consistent, are they almost exact?
yes, so we received the NAR standards that are those exact.
NAR is the
requirements,
national, right?
national,
Okay.
yes. So we received those national standards that are trademarked and sent to all of us, and that is accessed on the NAR website. So we have all of that.
So would there be opposition with GAR or NAR? Again, angry Americans against acronyms. I will point that. I'm still the only member. Would there be opposition, do you think, from GAR or NAR if we ask DBH-DD to adopt those standards when approving a sober living residence in Georgia?
I can only speak for GAR. For NAR, I'm sure they would support us in that, but
You said copyrighted somewhere in there.
yes, we would have to make sure that we get their permission.
You know, it always bothers me when a group or an organization, and I'm not talking about GAR, they come from a place that you think is a place of compassion and they copyright their plan. I mean, I'm gonna have to double check, but I think I can use Bible scripture without referring back to the author and giving credit to whomever.
Well,
so
unfortunately,
just,
set up because there were some other bad actors that wanted to do the same. There are some states that say we require you to have a national association. And so someone just said, oh, I'll just copy this and, make my own organization and we're good to go. So they had to do it out of protection. But if they're supporting us as an affiliate and if the state wanted to work together with us, we
Yeah.
are very.
because one of the problems we have nowadays is we have a lot of associations that come up, and you just kind of pointed out something. We were here during, it was a very contentious after the 2020 election, I think, and I think we were in this very room, and all these different organizations were coming up and associations were coming up. And as they were coming up, they were explaining what their association did. And it was an association, I'm sure, of maybe one, maybe five people. And as I was looking up there was no website, there was nothing. They were just, basically everybody starting their own thing. And so I have some concern about taking any association and codifying it in state policy or legislation. But I think there are some associations, and I think GAR is one of those, that has set itself as a standard when it comes to what we're talking about. And so if somebody like DBHDD were to adopt those same standards into their policy, then I think that would be not only it would make the state look that we weren't the experts, but that we were leaning into the experts to follow their lead, while at the same time, it would also, I think, show GAR that they are on the forefront of doing what needs to be done.
Absolutely.
And it would basically make everybody qualify for GAR membership,
Yeah. Absolutely.
which from a liability standpoint, I don't know why they would not want to be
Yeah.
a member of GAR, because if something did happen, I had funny enough, this past Saturday, I think it was, I was in a Hobby Lobby picking up some stuff, and a lady started talking to me, and there was a couple of people knew me and mentioned what my retirement job is. And this lady asked me what I was doing, and she looked at me and she said, "Well, obviously you're a Republican." And I said, "Why is that?" She said, "Well, you look like one."
Oh, no.
And she said, and she is not one. And so we started talking about recovery and other things about the study committee, and her son died while in recovery. Was on a job release program and went out and used and died. And so she and I got into an in-depth conversation about this, and her concern was, and it was in another state, it was not here in Georgia that he passed away or was in recovery, but her concern was there were no standards. And so she had no avenue to say should they or shouldn't they. Of all she knew is that something bad happened and she lost her 32-year-old son to addiction. And so thinking about that and discussing it, and when we started talking about GAR, and Jeff's always been a champion of GAR, when we started discussing it early in these meetings, everything sounded really good. The physical thing scared me a little bit,
Of course.
but speaking to the expert at DBHDD, we saw a path where we could do the good that GAR's doing without writing legislation for that, and basically consolidating the responsibility of certifying or defining what a certified sober living facility is by using those parameters.
Absolutely. And what is exciting is that there are some additional things we've discussed, like background checks, and we would love DBHDD's input on what that would look like. And we want to see that happen. It's just that, having those additional resources, such as a lawyer or anything like that, would be so helpful to discuss what that looks like.
Yeah. And look, background checks and criminal history, all this other kind of stuff. Look, we used to hire people all the time, and I was in a law enforcement agency that was several hundred people, and we put the responsibility of the expenses of the background check and the criminal history on the individual that wanted to be a part of the show.
Yeah.
And so, we said, we'll be happy to bring you on, bring us a copy of your criminal, because to get a criminal history and a background check on anybody, the individual that you're doing it on has to give you permission to do it.
Yes.
Because a criminal history belongs to the person. It does not belong to the state. It does not belong to the United States. And so that was some of the positive things, because the people that we do want in this industry are good people. And we do know right now there are bad people in this industry. And somebody mentioned something earlier and basically referred to sober living as a business. And to some degree it is.
Absolutely.
Just like a church is. And just like other things that sometimes we like to look at in a brighter, more beautiful light, it is a business. But I can't imagine anybody wanting to go into the sober living industry to get wealthy.
No.
Because what I've heard is, I talked to somebody the other day that's in one and, or he runs one. He's got about 160 individuals involved. And I asked him, I said, well, and this is his ministry. And I said, well, how do you afford this? He said, well, they pay $175 a week.
Mhm.
And I said, okay, well, that makes perfect sense then. I
Yeah.
can see that. And he's training them to be electricians, HVAC folks, and everybody in his program's a convicted felon. And so it works. And some are mandated there by the courts, but others are, it's a condition of probation and parole. This is in Alabama and Georgia. And so these things work. And what is GAR's thoughts on, we have THOR,
Yes.
which tell me what THOR stands for again?
Transitional housing for re-entry opportunity or the offenders. They were changing the acronym. I apologize.
You ever got in the ocean and then just rolled around on the beach and sand got everywhere and all that? I just feel that way every time I hear these god awful acronyms. And then, but THOR is where? Where's THOR?
Under DCS.
DC,
Yes. DCS.
DCS.
Yes.
Or DCS or DHS?
C.
C,
CS,
DCS.
yes.
Yeah,
Yes,
and then,
probation.
that's right, that's right. It's Department of Community Supervision.
Yes,
Yeah,
yeah.
yeah, Department of Community Supervision. And then where are the other lists? Are there other lists?
I mean, there's Joint Commission and CARF, but they don't really do recovery residences. They're
Is there another list of recovery residences? Or is THOR the only one?
Thor and GAR are really the only two.
Does it make sense to have THOR under Department of Community Supervision or DBHDD if we're going to ask DBHDD?
I mean, they're working with
These roles?
probation and parole and all of that.
I understand that, but
I would.
where do people go to find these lists? And you're on mic 4, you're hot, so, yeah.
I did have a chance to speak with a representative of DCS yesterday about the Thor list. What she suggested is, or what she outright said is they created the Thor program because there wasn't a regulatory
Right.
body overseeing recovery residences. And so we talked about what that might look like in the future if DBHDD were to have licensing authority. And she
Yeah.
said that they'd be very willing to work with us to transition some of that work.
Because I think what we really want is a one-stop shop, right?
Absolutely.
We want
100%.
not only those on probation and parole, but we want those who want to go live at Ian's place while they go through recovery because their family loves and cares about them to be able to go to one place and find everything. And because we did bring up, and he cringed when I said it, because we do want to create some kind of a fraternal connection between people going through the same thing.
Mhm.
It's okay if one guy's in one room and his family's got him there and he's supporting him, and another guy's in another room and he happens to be on probation.
Mhm.
That shouldn't,
Absolutely.
we shouldn't
Yeah.
segregate people just because of that are like-minded in recovery, correct?
Absolutely.
Okay.
Agreed.
And then so to have it somewhere, and as we walk through this, and not because Ms. Patel's on this committee and because of all the work she's done, it just makes more sense with what DBHDD does, that it would seem to fall under their mission more than other places.
Yeah, especially with them now handling the treatment centers and all of that,
Yeah.
it does make sense to have it all under one roof because there are a lot of places, like we talked about, that are IOPs, PHPs, the partial hospitalizations that are now opening up housing. And so that is
I
something.
like the way you air quote housing.
Yes, yes.
As if is it housing?
I mean, there are beds and there is a place for people to sleep and their electricity is on, the water's running, but,
Well, you just described some flop houses too, right?
yes, I did. Yes. And
Okay.
so, but they have because they separate the way that they do it, because of the way that they separate the two businesses, they don't have to and nobody knows about this other business. And so that's not being regulated. And then of course, they're not coming forward to get a GAR certification. So
Who's
that is
doing this?
a lot of IOP, PHPs,
Stop
intensive
doing that.
outpatient and partial hospitalization. So that step down after you do detox residential,
Right.
then you go to that intensive outpatient. So they're outpatient.
So it's a
program.
hybrid. It's a
Yes.
hybrid.
Yes,
correct?
yeah.
It's in between detox and sober living.
So yes, to a certain, yes,
Because
absolutely.
it has more of a healthcare aspect.
Yes,
to
yeah. So
therapeutic.
the client is going to the clinical office for a few hours and then going, staying somewhere because they maybe can't afford to go to a recovery residence. So there are a lot of things that we would love to sit down with DBHCD and especially with my personal experience in the field and have conversations of, hey, this is happening. We just want to make you aware this is how they're getting by.
And I've got a question for you, but
Sure.
Dr. Kirkpatrick.
While you're here,
Yes.
one of the things that has always been a little bit unclear to me is when you certify a facility, they meet all the criteria and then they don't at some point later. I had a constituent who died in a sober housing situation, and the person who was running the program was in recovery and relapsed, and this particular person died of an overdose in the facility. So I guess my question is, is it an annual inspection, or how do you determine if someone's still good?
So we start off when they do first apply, they pass, we give them what's called a provisional certification, and it's a 1-year certification. It's saying, we're getting to know you, you're getting to know us, and yes, you're compliant right now, we will be back in a year. And then we come back in a year, we do the entire thing over again, all of the paperwork and the on-site inspection, and then someone receives a certification for 2 years. And during that 2 years, we do drop-in visits. If we hear any grievances, we'll swing by. If we need to receive any paperwork, and then on a yearly basis, we are obviously getting their insurance, checking on if a business license is expired, making sure that they're updating that. Yeah, absolutely.
Who does the drop-in visits?
We have different members of the board. Typically, it's me most of the time, but then we have some like the city of Dublin works with us, and in order for you to open in Dublin, you actually have to be GAR certified, and so we work very closely with them. That will go in and do a lot more drop visits, and then we meet with them and let them know what's going on. But we have some, because Georgia is so big, and with my travel schedule, we kind of move around all over. Or we have our ethics chair who is more on the east side of Georgia, and so he does a lot more there. And then we have another board member that lives more in the south that does a lot more there. So it just
Is the state of Georgia divided up by regions with GAR, or is it just you happen to have board members that live in certain parts of the state?
we just have board members in different parts. We were trying to divide it up, but there's a lot more in different places, and so
Right.
by dividing up in different types of regions, the way that we're doing it didn't work as well. And so we're working on what's the best way the whole goal would be that, I could go get this place for a month and stay up in the north and take care of everything there, and then kind of travel around or whatever the case is. So
Because because to Senator Kirkpatrick's point, I mean, it's absolutely imperative that these places are inspected and
yes,
being consistent.
yes.
So if we were to set these standards from DBHDD in their policy, would it be the thought that DBHDD would have to provide people to go around the state and look at these things to make sure they're compliant?
I don't know what that would look like. I mean, GAR is certainly willing to work. I guess that's more of a
Because
DBH question.
as a member of appropriations, I could see where this would be heading pretty quickly.
So, yeah, it looks like you have a.
Yeah, well, I have good peripheral vision. I can see her.
Yeah.
Yeah. Because absolutely right. If you go in there and you're GAR certified to start with, or you meet all the qualifications of DBHDD to start with, and then 13 months, you just start letting things go down the pike, then we've got a problem,
Yes,
right?
absolutely.
Yeah.
Yes.
Okay.
Yeah.
All right. Thank you. Any questions? Anything else? Mr. Breedlove, anything you'd like to say? And if you say no, I'm gonna be shocked.
Mr. Chairman, thank you, sir. And thank you for your kind words. For the record, I'm Jeff Breedlove, a person in long-term recovery. And I think we should say, for the record, that since I was before you last, we have formalized a relationship between GAR and myself. So I am here on behalf of GAR today as a member of their team now, which is a change. No, simply the first two words are thank you to you and the committee members. It's so important to me The story you shared with the lady the other day, that story has been occurring in communities across Georgia. As people know the work that y'all are doing, and there are many, many, many families and many, many people who have survived who are very thankful for this deep dive. So just on the record, thank you very much. I do think that I would say you should have every confidence that GAR will be extremely supportive of whatever final language needs or not needs to be in a piece of legislation. And I believe our friends at NAR are only going to just send any kind of letter of assurance of that. So I would not worry at all about support from the two organizations. I am extremely confident you'd receive whatever you ask for. To your other point, it is interesting. It would seem to me that some entity would need to be able to travel on the front end and visit places on some professional schedule. And I've talked with others who I think GAR is more than willing to find its appropriate role as a non-governmental entity and be ready to serve DBHDD or any other agency in a way that they can facilitate. Like if a complaint comes in, can GAR be a part of that process in a legally appropriate way, but understanding GAR is not the state. And there may be a way where GAR makes recommendations to the state or something. So we're just ready to find the legal way that GAR can be involved.
I think you have to
shouldn't
be, I think
worry
you have
about
to be
that.
really careful
Right.
about letting associations come in there
Exactly.
because the state,
We know that.
and the state carries a very big hammer.
Correct.
As in local governments do and county governments do. And I think we have to keep the lines extremely bright.
Exactly.
Especially if an association, and I have no question about GAR's intent, but if an association charges a fee to be a member,
Mhm.
it gives them an interest.
Yep.
And so
Yeah, no, and
yeah,
that's what we're trying to say to you is it
we have
won't,
to be really
yeah.
clear because state and local governments are run on taxpayer.
right.
dime.
And you'll get no
So-
pushback from us
Yeah.
on wherever you go in that. We understand completely that point.
So, but my thing is, does GAR's role become that as an association? And you've already given an example in Dublin where you work with ACCG and GMA to be able to introduce GAR to their members so that GAR can become a part of the community when it comes to discussing how do we train our codes and enforcement people that when they go to one of these facilities, they understand what they should be looking for when it comes to an emergency plan, when it comes to all the rules and regulations that would fall under DBHDD,
Mhm.
and GAR just being somebody to educate them on that.
Yeah, I think
Um,
that education piece is massive. We were happy to help.
And I think what it does is I think it opens up an entirely new arena for GAR to get itself throughout the state so that you're not traveling to wherever and spending a month looking through recovery residences. And I want to be clear, when we say recovery residence, when we throw a lot of terms around interchangeably, but are we talking about sobriety residences or sober living homes?
Drug-free and alcohol-free, yes, yes.
Okay, good,
yes. Yeah,
good.
the same thing, yeah.
Because if I talk about a detox, I'm talking about alcohol-free,
Right.
not necessarily drug-free, because there's usually a pharmacy inside or a pharmacist that's giving it out.
Yeah.
So what we have to have is we have to have a single term
Mhm.
that we use when we talk about sober living residents, and maybe the easier language would be recovery residents.
Yes,
That term's in the law.
Yeah, because of that fact that it's already there. And sober is a really cool word.
means a lot.
But yeah, recovery residence does make more sense, and it does sound, there's not a lot of warmth in it, which is very much government. Because, we do our best work when we unplug our heart and do what's right,
Mhm.
and what's legal, and not try to get too much emotion wrapped up in it. So, I think that's probably what we would do. And by GAR being involved with ACCG and GMA, it does somewhat blunt the opportunity for DBHDD to come and ask for a whole bunch of money. When we talk about there's partnerships already out there between associations, 501c3s, which are nonprofits, out there working. And it does open up opportunities for grants and things of that nature through the opioid settlements and other things that are out there to hopefully help GAR.
Yeah.
Moving forward.
Absolutely.
And,
Do you want me to tell you what the definition is?
of what,
within the law?
recovery residents? Sure.
So what's in the law currently, and of course, we have different definitions in different code sections. also.
Shockingly.
But what was in Senate Bill 4, which is what we were talking about earlier,
Who's the author of that bill? Yeah.
back in 2021, recovery residence means a residential dwelling unit or other form of group housing that is offered or advertised through any means, including oral, written, electronic, or printed means by any person or entity as a residence that provides a peer-supported, alcohol-free, and drug-free living environment. So, I mean, we can certainly work on that
That
definition,
covers it, doesn't it?
but that's.
I think drug-free, when we realize drug-free, we're also talking about therapeutic medication too, where, because my understanding is if somebody's living in a recovery residence, it's up to them to go to CVS and get their prescriptions filled.
Yes.
That there is not an in-house and they take their own medication.
Yes.
There's no pill call in the morning and, we're not flying over the cuckoo's nest or anything.
Yeah.
They're living the same existence as we all do in our homes each and every day
That is, yeah.
while they're recovering.
Yes.
Yeah, they
Yes.
just have that unique crutch that some of us, or that unique disability that some of us do not have. Okay, well, good. Anything else from GAR now that y'all have brought Jeff on board?
No, we're excited and.
Is there
thank
a
you so
time
much.
period? Is it a 90-day window where you can let him go without cause or whatever?
We,
Have-
we,
It
It was like a week.
to 24 hours. Which was,
Yeah.
but yeah, no, we again, just very, very grateful to all of you for listening and letting us speak and bringing us to the table. This is massive for us. So we're very grateful, beyond grateful.
Thank you. I appreciate that.
Thank you.
Thank you. All right. Well, if there's nobody else that needs to speak or testify, then we're going to move on to committee recommendations that we've received. And I just handed one. Let's see. Yep. And Senator, if you'll look at I'll let you read that one.
Yeah.
You write like a
So
position.
we've got all these recommendations already, but based on the testimony that we heard from GMA and ACCG, it sounds like some clarification would be helpful. And so I'm just adding to recommendation 8, which is study zoning issues impacting recovery residences. I would like to add, including clarifying the definition of recovery residences. And I don't know where that'll take us, but that seems like everybody would be in agreement with that.
Okay. And one thing I want to do is the definition you just read. I'm going to read a definition out of Senator Jackson's recommendations on page 34 of Appendix B, where it says recovery housing is housing that provides a living environment free from alcohol and illicit drug use and centered on peer support and connection to services that promote sustained recovery, including continued sobriety, improved individual health, residential stability, and positive community involvement. I think the definition that you gave encompasses all of that, correct? Okay. So I know,
So if we can get the standards somehow put into state government, whether that requires legislation or not, hopefully not. I think that's going to help the cities and the counties to know what the standards are supposed to be.
you're on 4. Any comment on that? Do you think that definition that Senator Kirkpatrick read
I
seems
think
to
that
clear
covers
up?
it.
And we just take sober living residents out of the conversation completely? And
Yes.
just talk about recovery residents as the term? Yeah. And DBHDD had some recommendations, and do you want to speak to any of those? And before that, I do want to say I agree with you. I do not think we need legislation. I think we just need, I believe that you and the commissioner have kind of followed along with this entire process, and I think we've all understood it to the same thing as we just need clarity and we need the responsibility to be where the responsibility should be, and that's at DBHDD and not scattered about throughout state government. Would you?
I agree with what you last said. I think that we will need at some point some legislation giving us authority to actually regulate these facilities and shut them down if we need to. Levy fines, accept those fines, things like that. Those are things that without legislation, we can't just put in policy. Well, we can, but it probably wouldn't last very long.
Could be challenged.
Yeah.
That's what you're saying. Yeah.
Yes.
Because where in legislation now do we give that authority?
I don't think we do.
And that was,
Yeah.
that was my point. We don't, at nowhere, if there's a recovery residence in any county, then the only authority on that recovery residence is the local government, correct? And we have seen in some local governments where they have actually written ordinances that basically put the GAR standards in, saying that if you're going to have a recovery residence in our community, you have to use, and I believe they even reference GAR in their ordinance, as you have to have these standards, which are the NAR standards, the national standards also. So, so what you're saying is that you feel instead of the DBHDD working with local jurisdictions to establish these standards in ordinance, that you think the state should pass legislation that establishes these standards and gives DBHDD the authority to enforce the standards.
Yes.
Well, you could give them the authority to establish standards. You wouldn't have to
Right.
put the standards in the law because that would
Correct.
change.
Correct. Yes.
Right.
If I might.
Well, my question then is, how would you define the standards if you don't put the standards in the law? Because you don't want to put GAR and NAR in legislation.
No, but
I
they
wouldn't think.
They can put, if we give DBHDD the authority to
I see what
develop
you're saying.
standards for recovery residents,
I see what you're saying.
then they can decide what standards they want to use, and they don't even have to mention GAR. In
Okay,
fact,
we-
they
we
probably
don't-
should, but they
but-
can work with GAR.
Well, and I think there are no better standards right now, or no better defined standards right now than what NAR and GAR are using, correct?
Yes.
Okay. And have y'all looked at crafting any model legislation that says that at this point?
Yes, sir.
Okay. And that was done in-house at DBHDD,
Yes.
and attorneys were involved?
Are you going to share that with us at some point?
Yeah.
Yes.
Yes. Yes. And I'm going to tell you, and those are rhetorical questions. When I first got the information that y'all were working on that, I know that's more on your plate than what you normally do. And I greatly appreciate you doing that. That gets us so much further down the road than walking down the hallway and sitting down with a blank piece of paper and walking through it with the attorneys in legislative council. And I know legislative council appreciates the fact too, when that happens. So,
Can I add one thing?
absolutely.
We do, and it's included in my recommendations that were submitted, but we do think that there is a need for a network analysis before we put this responsibility on the state. We've heard a lot of testimony over the course of the study committee about there being, we don't know what we don't know, right? And so to put a responsibility to regulate maybe 1,000, maybe 1,500, maybe 2,000, it's very challenging to develop a budget. We just don't know what the fiscal impact is going to be, and we need to ensure that we've got the staff, because if we are required to do it, and we do think we should be required to do it, we want to make sure that we're doing it the right way.
And my cynicism says y'all do not have the staff and you do not have the resources and that the state will need to fund it all.
I'm confident in saying that we do not have the staff to regulate over 1,000 homes.
That's right. If there are 1,000 homes.
If there are 1,000 homes, but
And
that's
so the analysis, the problem with the analysis that we're going to have to begin with, and we're going to have to do it, is that, and I love, and one of our LA's legislative assistants has that, we don't know what we don't know on his desk, and I appreciate that. But we don't know what we don't know is a black hole that pulls us all in. And so what we do know is the fact that they exist in our community, but we don't know how many, and we have to come up with a way to determine. And I think the way we do that, or one of the ways we could do that, is put the requirements out there. And those that are operating that fail to meet those requirements, we're going to have to find a way to dig them out and either get rid of them or get them compliant. I'm afraid may be the only way.
This is the
People aren't
exact
going to self-report.
22
Yep.
that we dealt with back in 2021 when we started down this rabbit hole, was that because these facilities are only licensed under a business license and the Secretary of State was unable to find a way to split them out, I don't know how you would even do network analysis.
Unless, are we talking about a local business license?
No, a state business license.
Well, there's a registry of that.
our hope was to partner with ACCG,
Yeah.
GMA, and our Secretary of State's office, right? To begin to narrow down a list of, or to develop a list of these recovery residences. And we might not get all of them, right?
That's
But
right.
we'd have a better sense of what we need to regulate.
And we do
How many
know
we need.
where a lot of the referrals come from, and the healthcare community would have to be a part of the conversation.
Absolutely.
But I think that, and the reason I asked were the business license local, because that would require a partnership with the county association and the municipal associations where all that information is stored, at local governments and county governments.
So do we need to change recommendation 2 of our report?
Read what you're looking at.
I'm reading, authorize the GAR to serve as an enhanced
37?
certifier,
Page 37 of.
page 29. To serve as an enhanced certifier and advisory partner to DBHDD, but what we're actually talking about is authorizing DBHDD to adopt standards for recovery residences.
Yes.
So I would think we need to replace recommendation 2 with what I just said.
Yes, I think you're absolutely correct.
You're correct. Does staff get that?
Yeah.
Repeat it one more time.
Yeah, to authorize DBHDD to adopt standards for recovery residences.
On recommendation number 7, SUDS. Could somebody tell me what?
Substance use disorder.
Okay,
Why does it have a little S after it?
that was my, it's
Doesn't need to
possessive,
be
right?
there. That doesn't need to be there. We can just take that.
That's
little
fine,
S
yeah.
out.
Yeah, I was a little thrown off.
It's in a couple places. Do you need a motion?
I will in just a second. I want to ask, part of, in recommendation number 3, that would be the shifting this over to DBHDD. That would be part of the the model legislation, correct?
Prohibiting referrals?
Correct.
Yes, sir.
Okay. So saying that,
I think we still need to say that.
no, that's what I'm
Yeah.
saying. I'm saying
Yeah.
saying that.
Absolutely.
Basically, if you read through here, establish a comprehensive state licensure certification system and then prohibit referrals to unlicensed, and so on, that would be encompassed within the model legislation that DBHDD is currently putting together, correct?
Yes.
Yeah, so that way we don't have to say anything about the model legislation within these recommendations. And right now, I'm looking at 8 recommendations. Is there any committee member here that has any heartburn over those 8 findings and recommendations?
I don't have heartburn over 8, but I do, who would study that?
I think, again, that goes back to the partnership that we would need to have with GMA and ACCG. In study zoning issues, and a lot of times it's any other audit of policies and procedures or SOPs to where we would lean into our relationships with those 2 organizations, and they reach out to their membership and basically say, hey, we would really love for everybody to review their zoning requirements over recovery residences in their communities. And I promise you that they're going to get out of the 500 plus membership that GMA has, some of those are pretty tiny communities, cities, and a lot of them will not have anything on recovery residences, and their response back to them would, we don't have anything on that. And just having those numbers will give us an idea of exactly what we're dealing with. And
So maybe if you are paranoid about that, what we
doesn't
could-
have heartburn, she's paranoid.
what we can say is
No,
work with, I don't know if you want to name.
No. I think 8 is as written
Okay.
gives us that opportunity to partner with them. And because I always hate to say this, but we could go to GMA and they go, yeah, we'll be happy to, or we'll be happy to do that. And then we go to ACCG and they go, hey, look, we just don't have the bandwidth to do that right now. We'll do something else. I don't want to obligate associations to doing stuff, but I think there are avenues for us to study this, whether we do it through those organizations, which are by far the best way, or whether we have to lean into Carl Vincent School of Government or somebody else to do that. But I think we have the resources to study zoning issues impacting recovery.
It wouldn't be you.
residences.
It wouldn't.
No. I don't.
That's what I needed to hear.
Yeah, no. I don't. I think it would be you in partnership. Is actually what I think.
And we're
I
open
think
to
I
that.
think you guys are going to have to be the experts on this. I really do. And I think that's shown throughout all the testimony that DBHDD is the tip of the spear on this. Congratulations.
Happy to be here.
So with that being said, I will need a motion to adopt findings and recommendations on page 29 of 37 on the 8 recommendations, unless there's a motion to remove one or any.
So we made a couple changes along the way,
Right.
but.
As changed because this
Yeah.
has not been voted on yet.
Right, so. I'd
What
be-
we're voting on is exactly what she has,
Yeah,
which has the changes in it.
right.
Yeah.
Okay.
Yeah.
So,
Because none of
So
this
I'm
has been,
happy- I'm
there's no
happy-
amendments needed.
yeah, I'm
That's-
happy
yeah.
to make that motion.
Okay, I have that motion.
Second.
Have a second. Any discussion? Having none, all in favor, raise your hand. Because there's 3, the chair votes. All right. That being done, anything else for the committee?
A thank you from DBHDD.
Well, listen,
including us.
and I do not say this lightly.
Another
I know I have a sense of humor that is sometimes not appreciated, not intended. It's just a warped personality, but I really do appreciate everybody that's been involved in this. I do not know why I get so obsessed with these things, but I think we do run over so many things in this building so fast that we pass legislation and we pass rules and regulations that we fully don't understand at the time, and we don't understand the impact that they have. And we do a lot of things without leaning into these associations and these other groups that are the subject matter experts. But I do honestly believe in the deepest parts of my heart, if we don't peel back as much of this as possible and get the rot out of it then we fail. And so I really appreciate y'all doing this. I think doing this, we have intentionally or unintentionally given Ian and his group an opportunity to help a city correct what I believe is an unintentional error. And I certainly hope so. And we're going to be watching that closely, and we want to stay involved in that. I want to thank everybody that has chosen to to sacrifice a big chunk of their life and their finances to get involved in this business of saving lives. I really appreciate that a lot. I want to thank DBHDD and the commissioner, Kevin Tanner, for his commitment to make this a priority here in the state of Georgia. And our friends at GMA and ACCG, I want to thank y'all for always being at the table with us to help us take the right path and occasionally help us cut new paths. So I do appreciate all that. Staff, I can't thank y'all enough. Y'all know I'm always going to have your back. I'm always in your corner. And if I can ever do anything for any of y'all, you know, all you have to do is reach out. And I'm thankful for the new friendships too. It means a lot. And with that being said, if there's nothing else brought before the committee, then this study committee is adjourned, and our report will be out. Our final report will be out by December 31st. Thank you all, and God bless you.